and this will be recorded.
Okay.
I believe the webinar has begun.
Okay. Good morning, everyone. I'll wait till the attendees also get populated so they can hear. Looks like we just have 2 attendees right now. Good morning, everyone. I'm Erica Yu, and I have the pleasure of heading up our subcommittee, which is to look at a pilot program. This is our 3rd meeting, and today we're hoping to do some work, although we are going to 11:30. We have one more meeting on the books, and we kind of want to give you a heads up that we think there'll be a need for another meeting. We also have found that as we're looking at the pilot issue, by nature of that, we're kind of being pulled into also looking into the evaluation issue. And in my experience, setting up an evaluation procedure can actually be the work of a whole subcommittee. So I checked in with Justice Petru, and she gave us license to not have a fully formed evaluation tool or committee. We can work primarily on the pilot and know that the evaluation piece will be sort of a placeholder. In addition, Andrea, Christopher, and Sharon were kind enough to meet with the legal service agencies, and they're going to give us a report. And then we have a tool that Christopher and Andrea were so kind to set up for us, and I'll explain in more detail when we get to those slides. But we have a very short time frame. We're supposed to have some deliverable to discuss at the February 26th meeting. So as a result, we thought it would be easier for us to just kind of build something for people to look at what it might look like and then tear it apart, as opposed to us kind of dealing amorphously with concepts and philosophies and not really having something concrete. So you'll see what we're talking about when we get there. It's like it's a ship that you can blow up or add things to. It's just really an evaluation or a tool for us to get started. So with all that being said, I know we want to check and see if there's any public comments. So if you're an attendee, could you please raise your hand, and then we can get public comments. I don't see any. Okay, so since there don't appear to be any public comments, I'll ask Christopher and Andrea if they could please start us off by reporting back from their meeting with the legal service agencies. And please, Sharon, if you'd like to jump in, please do so.
Thank
Great,
you.
and I'm going to share my screen, Andrea,
Yes.
with the slides.
Okay, great. So we did meet with the legal services community last Friday. What inspired that was, I understand that there was another meeting with the legal services community on this working group, not specific to the pilot, back in October. And we thought now that we're exploring a pilot model, it would be helpful to get some feedback from the legal services community in a forum that allowed for more than just a couple minutes of public comment. Because of Bagley-Keene and the pace of everything, we didn't invite the whole committee because we didn't want to run into Bagley-Keene issues because it all moved quickly and we didn't have enough opportunity to be able to notice it. So instead, we wanted to come and report back. So the meeting was well attended. We had about 25 participants, including from some of the larger legal service organizations, Betzetic, LAFLA. We had attendees from LAC and other folks representing some additional perspectives from the legal services community. And we wanted to, again, allow this forum to both collect specific feedback from the legal services community so that we can consider it as we're building this model, as well as just make sure that, there continues to be multiple ways for different community stakeholders, legal services community being one of them, to engage in this process. So I think the fact that we held this was well received. We got positive feedback on providing this forum. And so, we did mention at the end of it, it's something we can consider doing again, especially as this model moves forward. So that's on the table as a possibility to do another convening like this with the legal services community or otherwise. So wanted to share out on some of the pieces of feedback. So unsurprisingly, a lot of feedback on making sure that we're protecting consumers. So we made sure to frame this by saying, as we talked about at our first meeting, the very nature of a pilot, I think, is a risk mitigator for any consumer, any client concerns, because it's going to be, by definition, on a smaller scale, and we're going to be evaluating the impact on legal consumers. So I think the concept of a pilot was overall positively received. We also shared, as we framed at our first meeting, that not building a pilot is an option. This is not a foregone conclusion, but in the process of having a formal working group, we're of course very seriously considering the viability and possible benefits. So some just quick pieces of feedback to share. Screening for unscrupulous providers, of course, something that's being talked about in this and other committees, subcommittees. Setting a high bar for knowledge and experience. And we did share some updates on what the subcommittees focused on, the training and licensing piece have been working on, narrowly tailoring areas of law and activities. So we did reassure attendees that the pilot committee is not operating in a vacuum. So these very in-depth discussions, for example, in family law on the areas of practice within family law that would be appropriate for a paraprofessional program, all of that wisdom is being captured in what we're looking to build. So we're not just, this isn't, you know, a completely separate process from all these other subcommittees. Starting small, we've talked about this, and you know, I think everyone agrees that there was consensus, might be a strong word. There was pretty consistent feedback that geography was a really good way to limit risk and be able to study the impact in a pilot, and narrowing by practice area. So I know this one we're concerned about whether it would give us useful data about a paraprofessional program if we use attorney supervision just for a pilot, but that topic did come up, and the legal aid, oh, sorry, was there a comment? There was, I think this is consistent with what we've heard from some public comments and some other feedback before, but a lot of support for the idea of considering using attorney supervision for purposes of a pilot, or at least maybe having a model where attorneys review certain written work products or other parts of the process. So something that was thrown out there. Also the concern that we don't want to divert people that qualify for legal aid and would have access to those services into a paraprofessional and route them to a paraprofessional instead. What I shared, and hopefully was clear to the community after we talked it through, was that, you know, I think we've said this before, but that is not the goal of a paraprofessional program, to take clients that qualify for legal aid. And really the client base that we would anticipate serving through a paraprofessional program, as we've talked about, is more of a likely modest, moderate means income client. We anticipate that is the biggest service area and where we see the access issues that this would be best suited to address. So one, just a comment that came up in that context was the possibility of just having certain criteria or a checklist to make sure if a client does qualify for legal aid, that's where we're sending them. And then in some cases, a paraprofessional or an attorney, you know, a for-profit attorney may be the right route. So we, you know, did try to alleviate some of.
Can I just jump in for 1 second? Because I certainly appreciate that consideration, but I also appreciate client choice. So for example, if a client qualifies for legal aid, they should certainly be aware of it. That's something that I would contemplate being on kind of that introductory required form that they're required to sign off on. But we also, you know, need to hold the fact that clients have choice. And if they qualify for legal aid, but they prefer to hire a paraprofessional, it's certainly their right to do so.
Yeah, absolutely. No, thank you for that. I think this was just to say that we want to make sure people are making an informed choice, right? So especially if it's someone that might not be aware of all the different resources available, we want, especially when even something that we would consider a lower fee may really be a burden for someone who's in this indigent category. So. But your point is well taken. Concern about in-court representation, which I know, I did let them know in-court representation is still something that is in consideration, although I don't think we've made a clear decision around that.
And I'm so sorry to interrupt, but I wanted to just kind of also let Justice Petrell and the committee know that Her point was taken in this context too about whether or not there would be in-court representation. So for example, for Bay Area Legal Aid, when I was hearing the unlawful detainer cases, Bay Area Legal Aid primarily gave assistance outside the courtroom and very rarely came in the courtroom. So if we decide our paraprofessional program would allow paraprofessionals to be in the courtroom, and in that geographical area we choose legal aid doesn't go in the courtroom, then certainly the client should know what all the resources are, what the options are. But it may be that it would be better to have a paraprofessional who would go in the courtroom with you. So I think this feedback from the legal services and community is all helpful, but it's going to be up to us to make these final decisions.
Yeah, and to be clear, I said we really wanted to allow, we want the feedback and we will absolutely take it seriously and consider it.
Yes.
But, it's not that, it was very clear that the context wasn't, you tell us how to do this. It's more, we want the feedback from multiple stakeholders in the community as we're talking through these complicated issues. So
And
there was no other promises made.
And the legal services community has seen quite a bit of abuse in the past, so that's where they're coming from, their perspective.
Yeah, absolutely. And everyone agreed at the beginning, we all want to increase access to legal services, but given some of the issues that, this community has seen, there's just a lot of sensitivity around protecting clients, which of course is something that we all take seriously as well in anything we recommend.
Andrea and Erica, I apologize. We did a very informal roll call before the meeting began as we were making sure people had arrived, but we should do a roll call for the record when appropriate. Judge Yu.
Thank you. And Andrea, since we've interrupted you multiple times, do you mind if we do it now, or would you like us
Not
to
at all.
wait?
Please go ahead.
Yeah,
Okay.
sorry from me too, Andrea.
Not at all.
All right, I'll take roll now. Bashan,
Present.
Thelmuth,
Here.
Kirkmeyer, Petru,
Here.
Sarush,
Here.
Hamilton, and you.
Here. And I'm sorry, Christopher, that's on me. I should have started that out with that. Thank
Oh,
you.
that's perfectly fine. All right, and sorry, Andrea.
Not at all. I'll wrap up shortly here on this, and then invite Chris and Sharon to share any other reflections. Just to share with the committee, there was support for the idea of capping services for paraprofessional fees, which I know is still something in a pilot program or otherwise that is undecided. But I think I've heard people kind of leaning against that, which I did share back. But I wanted to mention that came up. The two other topic areas I wanted to mention that were discussed, we've talked about piloting in rural areas, particularly because there's oftentimes significant service gaps, oftentimes poverty concentration, as well as fewer attorneys per capita. So I think there's a compelling case to be made about piloting something in a rural area, but a fair point was raised by, goodness, I forget the name of the legal services nonprofit, but a smaller one, I believe from the Central Coast. And the comment was there's a concern about the bandwidth in some of these more rural areas and smaller communities to be able to help support a program like this on the court side and on the attorney side, legal aid or otherwise. And in terms of oversight and training. So, just something as we continue to consider geographic structures. And a point that was made that I wanted to share out, I believe this was Tila's point. And in talking about a paraprofessional program, one concept that she had was this could be, if we do it right, a really wonderful way to empower former legal services clients. So she gave the example of a domestic violence survivor who might want to consider then becoming being licensed as a paraprofessional and helping other survivors navigate that process. So, I think that could apply to other topic areas as well, but I thought that was an interesting kind of vision for one way to use paraprofessionals that would be empowering for the former legal services clients, as well as I'm sure in turn any clients that they would have. So those were some of the takeaways I wanted to share. But Chris and Sharon, please jump in with any other feedback from that meeting.
I'll let you go first, Sharon.
Oh, I think you covered it pretty well, Andrea. So thank you. There was one point that was made that I thought was an interesting point, which is when a client comes to a legal aid office and maybe they're coming for a specific issue, like I want to get divorced or I'm getting evicted. There's a holistic intake that's done. And oftentimes you find a lot of other issues besides what they're coming for. Maybe there's a public benefits issue, maybe there's a consumer law issue. And that assessment is done. And then, appropriate services are decided on. There was a concern that with these paraprofessionals, if they're so specialized, that part may be missing. And if I thought that there was a suggestion of if there's a way to collaborate with lawyers or make sure that type of holistic assessment is done, it would be better for the client.
Thank you. That's an important point.
That was such a great recap, Andrea. I don't think I have anything else to add.
See if there's any questions then.
Good morning, everyone. With regards to Sharon's point, I just ran across a case this morning that really just gives you an example of how bad things are out there. While I really like the approach of legal services agencies, sort of this holistic approach, we do that here as well and point out any other issues we spot at the Self-Help Center. But what I see a lot of times out there is just basically typing services where the client goes in and says, I want this. I go, okay. And the one that I just ran across this morning was a contempt action filed by the restrained person in a restraining order saying the other party violated their own restraining order. And it was a legal document assistant that did that work. So, and I've seen this over and over where they go in, they say, this is what I want, and there is no analysis done. So to the extent that this program will kind of require that from paraprofessionals is great, but at the same time, these are not attorneys. So I don't know where that sweet spot is, where that balance is, where they do this holistic analysis to a certain point, and then beyond that is really not their responsibility. And Sharon, I'm thinking that this kind of holistic review is done by attorneys, yeah?
At these agencies generally, but it's just also a matter of the right training, and it would be up to us to decide how that gets done. Because I think sometimes the problem is if you don't do it, it can bite you later. And the client there may be something that's missed.
Yeah, I just don't want to put too much responsibility that doesn't belong there and hinder them too much. But again, where is that balance? Where's that spot?
Yeah, no, thank you for that consideration. I do believe sometimes that kind of intake is done by non-attorneys on the legal services context. And, there are tools to talk through some of these considerations. And, we could think about that kind of whatever we want to call it, intake tool, triage tool, routing tool. I believe, Judge, we'll talk more about routing in a little further along. But I think something like that actually may be very appropriate for a paraprofessional. But given that we're talking about this all in the context of a pilot, we also have an opportunity to test a tool, right? And then learn from it. So the whole beauty of a pilot, there's challenges, but the upside is we could test it. We could say, let's try this kind of tool and see if it works well in this context to help a paraprofessional with the analysis and learn from that. So
if I could jump in, thank you, Andrea. So I had said there needs to be some type of routing tool anyway, because we're not going to have every case go into it. So we're going to have to decide, is this a UD case or is this a family case? And we're probably not going to have every family case go in it. So is this the type of family case that we've decided should be part of a pilot program? So at some point, there's some routing that's going to happen. And so there can be some information, training, or education that will help us get people to the right place for the initial parts of the of the pilot program. We just have to figure out where that is and what that looks like. And as you'll see in the future slides as we get there about what we've put together for people to just think about what it could look like and push up against it, take pieces off, replace other pieces. But I think this conversation is really helpful because it's helping us think about what we're going to have as a routing tool.
Great.
Yeah.
That seems like a good transition. Unless anyone has other questions. If Judge you want to kind of frame this this just draft proposition that we have for what the model might look like.
Okay, why don't we put that slide up, please? Thank you, Christopher. Okay, so this is really basically I'm going to call it a dummy pilot program. Dummy meaning it's just something that we can take apart. It's a crash dummy kind of, that's just a test dummy. It is not in any way meant to be a recommendation. Nothing in here is a requirement. All the factors are subject to change. You can blow it all up and reconfigure it. What I didn't want is for this document to get out and then people say, oh, now they already have a pilot program and they haven't talked to us. It was just, we don't have very much time. And it's, at least for me, so much easier to actually see something and then see what I think should be changed, as opposed to like not knowing, having too many pieces that are working parts and not knowing where they fit together. And I really want to thank Christopher and Andrea for coming up with the idea of giving us something to really test our ideas against and to put something there on paper so that we could pull it apart and make it what we want. So Andrea and Christopher, would you mind kind of explaining this tool that we have here?
Judge you or Erica, speaking of blowing it all up, is there any way you can make this larger?
Yeah.
I know it's a lot of text and we're about to frame that. So Chris is going to talk about it just so we can see the flow. And then we have slides breaking down the parts and we can figure it out afterwards. We know this is really busy, but we decided we at least wanted the visual and Chris can frame it. And then each section will be in much larger font. So we really understand your comment.
Because I said, I have old eyes. It's hard to read, especially when it's in a Zoom format. So we want you to see the overview and then each section is its own slide. And we can have Christopher kind of zoom in on things too. Thanks, Julie. Go ahead.
So Erica, I've got some, not feedback, but I have some things I'd like to share from having presented to the State Bar Board last week.
Thank you.
That maybe would make sense to share, I don't know, once kind of the overview of phase 1 is done.
Okay.
Great.
Please go ahead. That'd be helpful.
Okay, so the
okay.
Oh, do you want me to? Okay, so let me just throw in a couple of things, but I don't want to sidetrack the conversation, but I think it's important to keep in mind. One thing that came up was, is our program going to require legislation? And the short answer was, while technically maybe not, yes, that's what we would do. So I have the immediate question of how does that legislation work? If there's a phase 1 that is not a fulsome program. So for example, anyway, putting that out there, legislation required to be discussed. The other is that there was clear feedback when talking about the barriers for entry. And by barriers, I simply mean what are the criteria, the educational requirements, the attorney supervision hours, all of it. The general feeling was it was too much, that we are making it too difficult for people to become licensed as paraprofessionals. And I can certainly tell you from just giving the quick eyeball to the phase 1 here, that would engender an even stronger response along those lines, with the concern that it's going to take a very long time to actually get anyone to be able to do anything. Part of the pushback around the 1,000 hours of attorney supervision was, okay, you're requiring people to already be JDs or LLMs or paralegals. Then you're requiring so many educational hours, and then you're requiring 1,000 hours, and we don't even know how you're going to find attorneys who are willing to supervise those 1,000 hours. So I give that as backdrop to say that we need to hold that in mind when making it an even longer period of time before people can go out and do things. Okay. which is not to be like a Debbie Downer about all of it, but is to say that was the feedback that we received based on the tentative program outline that did not include a phase one that would be lesser than the actual program, other than I did float by them the concept that there would probably be a phase one limited by case type, for example, and potentially by geography. But I did not mention other things such as only certain things within the case type or requiring additional supervision or steps.
That is so helpful because I'm glad you are telling us upfront, so it really will inform our discussion. Is there anything else that you wanted to share from your meeting with the board?
No, and obviously I was very clear with them that we weren't putting forth a proposal, and so they were reacting to kind of our preliminary thoughts, but still I think the reaction was important to keep in mind.
Okay, thank you so much. And thank you, Christopher, for pausing, and go ahead.
Yeah, and this, my piece will take a minute or less because I don't want to take up too much of your time. I just wanted to corroborate that this is a lot of information on one slide. So my piece is just to kind of give you the theory of the breakdown and to disclaim that this is not a recommendation from staff as much as it is what Erica described, which is something that the subcommittee can just kind of pick up and turn around and poke at and say, I like this, I hate this. And then in the staff's notes, we'll try to capture the direction the subcommittee is moving such that we can present a new version of something like this in the future. Okay, so the sort of concept I wanted to describe that makes this a little easier to navigate, and like Erica said, the subsequent slides kind of break this out, is the phase one here proposes to test the assumptions about legal paraprofessional services, that they're safe, that they're effective, that they close the justice gap, and it envisions heightened safeguards that might not exist in phases 2 and 3, and those could be something like legal experts, attorneys that maybe receive a stipend from paraprofessional participation fees that audit work product for over the course of a year, and but that doesn't feature in phases 2 and 3. So you can imagine some situation where phase 1 has extra safeguards that phase out, and because it's focused on sort of just testing that underlying assumption, it limits the geographies and the practice areas. Phase 2 assumes that it's safe, it's effective, it closes the justice gap, it's working, and it really tries to imitate the entire program as it will one day look. It tries to pilot all of the entry requirements that will be the permanent long-term entry requirements, anything that needs to be tested, it scales it out. So more geographies, more areas of law. Phase 3 would be, if it still needed to happen, it would just completely finish scaling up so that it covered all counties and all areas of law if phase 2 didn't already do that. I can stay on this slide as long as you like, Erica, but since the subsequent slides break it out, I can also just move on to the next one. Okay.
Yeah, I think you should move on. I do want to just thank you for, because some of this reflects what is a synthesis of past discussions. So thank you for doing that and putting it on paper for us. But yeah, I think we should blow it up a little bit.
And Chris, if you don't mind, do you want to just talk us through this phase? Because I think your thinking on this is really helpful. And then Erica and I can, jump in as we go.
Yeah, I'd be happy to. So I'll give you like I'll try to keep it to my 1 minute overview. So the phase 1, I think the two sentences is worth reading aloud. So phase 1 concept at the top. It tests the potential for safety and efficacy with heightened safeguards. It would resemble the ultimate program only in part, since it would be testing assumptions about the services rather than the program apparatus or features. So when we were designing this as a proposal, we were influenced by the meeting with legal services stakeholders that they were encouraging the subcommittee to keep it small in geography in the very beginning, phase in additional counties as you go along, maybe start with 1 or 2 practice areas to test the waters, work out the kinks, and then phase in other practice areas as you go along. The activities would be the legal matters on which legal professionals could work. There was a sense from the legal services community that maybe this subcommittee should just defer to the relevant practice area subcommittee that's already working on that. So we just have defer to the other group. Entry requirements to stand up a pilot within the year. If a curriculum is not yet available, you might be limited to some combination of existing credential, perhaps years of relevant practice, or attorney supervision if you wanted to make sure that someone who just graduated with their JD or LLM.
Well, I'm sorry, but I'm confused. Is the attorney supervision, you mean, because right now, the proposal for someone to have a paraprofessional license contemplates 1,000 hours of attorney supervision. And that may change, that number may change, but it will be some number. So are you talking about attorney supervision during that period of time, attorney supervision in addition after that period of time?
Great question. This slide was contemplating attorney supervision during the pilot if they didn't already meet the pre-existing years of relevant work experience. So if you wanted to make sure that someone who just graduated with their JD could participate, or they just got their LLM 6 months ago.
Okay, I'm sorry, I'm still confused. So let me give you a concrete example.
It's basically a placeholder. It's not, it can be changed.
No, I understand, but I'm trying to understand what it means. So for example, I got my JD. I now have my paraprofessional license, which included 1,000 hours of attorney supervision or whatever it is. Okay. I am now part of the pilot program. Are you saying that in that context, I still need attorney supervision?
So Erica and Chris, please correct me if I'm misconstruing our conversations about this, but so what we talked about, the three of us, but also in past pilot meetings was the possibility, although obviously not the recommendation yet, of substituting for purposes of a pilot certain other requirements like 1,000 experiential hours under an attorney for other safeguards. So in this instance, I think instead of having the fully formed ultimate educational and licensing structure in place, a possibility to help speed up a possible pilot launch would be requiring attorney supervision of the work itself in lieu of those other requirements that we might otherwise recommend for a full program. It's just a possibility to fast track being able to test a pilot model. We've touched base as a committee, but certainly hadn't settled on it being a good idea.
Yeah, and I think that's a very fundamental question that needs to be answered is, are we contemplating some alternative to the full licensing for purposes of a pilot program in order to get people out faster, which I have to say, I see a lot of pluses and minuses because, part of the whole licensing scheme is to ensure a certain amount of public safety. And I'm a little concerned about setting up a parallel program while also being very concerned about how fast can we start getting people out.
Right. And I think that's the philosophical debate that we talked about at our first meeting, but really didn't settle on. So that's my thinking about what this means. So we, said, what would allow us to do something fast and test this, right? Because if we can't do a pilot quickly, then we can't get the data, we can't get the information. So, it kind of defeats the purpose. So how could we stand something up quickly? And one of those ways is to require attorney supervision of the paraprofessional as they're practicing instead of some of these other prerequisites, barriers of entry. And there's a lot of upside to that. But the downside is, of course, then are we really learning how well this works and how well it protects legal consumers? Because if an attorney is not going to be supervising the work in a full pilot, are we learning something meaningful? And we'd understood the committee had not actually decided on that. But Erica and Chris, let me know if I'm mischaracterizing, kind of your thinking on that. But I thought this was still sort of a pending question for our subcommittee.
Yeah, it's definitely pending. This is really just a tool to give you the subject areas where we're going to fill in as we discuss. After Chris goes through the next 2 slides where he blows up each phase, then we have a slide that has all the various factors we want to think about as we start to make decisions on our recommendations for each of these categories. Any other thoughts or questions so far, though? This is all helpful because it's moving us toward that larger conversation that we need to have as we address some of these concerns or questions. So anything else?
Well, my only other comment is that right now, and we'll talk about it when we drill down, I think we need to, make sure we're going to be able to get sufficient data to understand if a program is working. And we've talked about this before, limiting the number of counties, limiting practice areas, certainly with sublimits beneath those, there's that just concern of getting enough information.
Right.
Yeah.
I think there's just going to be a tension for this pilot conversation between getting enough information and meaningful information and doing something quick.
Yeah, and that's why evaluation and pilot have sort of blossomed together and become a bigger project. Yeah. Thank you.
I'm sorry, did you
Yes,
call?
go ahead.
Okay.
Yes, Fariba,
I'm just listening to everybody, and I just keep kind of thinking about the goal of a pilot being to see how the project functions in real life when it's launched. So to the extent we can stay away from any sort of artificial setup or a temporary setup that's not going to happen in real life. Like, we want to see how these folks operate independently. If the final project says they don't have to have attorney supervision after they're done with a certain number of minimum hours and they're fully licensed. So I hope I'm not misunderstanding the conversation here, that at some point during these 12 months, we're gonna allow these paraprofessionals to operate independently.
And I have to really echo what Fariba just said. I think it's very important. I think it's also important that we don't present to the state bar a incredibly complicated program recommendation with a whole different set of things for pilot versus what we're going to do permanently, for lack of a better word.
Okay, very helpful. And then I'm sorry, I didn't notice earlier, but I see Kimberly's joined us. So hi, Kimberly, and I want to just make sure that you don't have any questions about what we're doing or where we are as we move forward.
No, thank you so much. And sorry for being late. That's definitely a conflict, but I just want to actually echo the comments that have been said, because I do think it's important that we measure the effectiveness of the program based on what it would look like as a program, not bifurcating it.
This is all really, really helpful, I think, to us. So thank you. Anything else before Christopher kind of gets through this? And then
I just wanted to summarize, because I think last time this topic had come up, like, what do we do again for speed? That shortcut sounds like a negative word. A more positive word for shortcut that allows us to I'm not saying it means to be more positive, that allows us to do something quickly, but is still meaningful. And I think we were not sure, but it sounds like this feedback is leaning towards, even if it's going to slow down launching a pilot, that this subcommittee is leaning towards something that is very closely reflecting what we would ultimately recommend for a full pilot launch. Is that more or less?
Well, explain to me what's in this phase 1 that would actually make it faster, other than, I'm still not fully understanding the attorney supervision, but what in this phase 1 would make it faster than going through the standard protocol?
Well, I think attorney supervision could theoretically be a substitute for those prerequisite of those practice hours and those other things that are being contemplated. That's the context in which we talked about it previously. But I'm understanding the feedback, which again, we weren't recommending that or not recommending it. The feedback seems to be
but other than the attorney supervision, what in here would be faster than what we're contemplating for the general licensing?
I just think a small, I think
what you're trying to say is this pilot doesn't contemplate piloting any of the licensing proposal.
Yeah.
So what makes it faster is nobody has to get any educational credits and nobody has to get 1,000 hours of attorney supervision. So that whole piece is
out.
eliminated. That's what makes it faster.
And
There's-
also, I think our choice of location will just help to make it faster or slower. So for example, if we don't want to worry about testing whether or not a paraprofessional can be in court, then we should choose a location where the legal aid services do go to court with them, you know, as opposed to like my jurisdiction where the legal aid services, at least when I was doing
Yeah.
standards, didn't go to court with them. So some of the choices we make are going to help us get to the ground faster than others. But I think we should kind of go through the next two slides just very,
Yeah.
very quickly if we can, Christopher, because we only have 45 minutes left, and then we can get to the slide with all the factors and really start digging in, because we only have one meeting set before February 26th. And if we set a second one, we still may not have enough to report back on.
That's great. And this conversation about exactly what the entry requirements should be, what the feature should be, is exactly what I think staff, what Andrew and I were hoping this tool would do. So far this tool is succeeding, is getting you to really grapple with it. So I mean, phase one, like I said, it sort of presupposes that the subcommittee really wants to test this idea that legal paraprofessionals services are safe and effective. And what I'm hearing is that assumption, or that has does not need its own phase to test. And so phase two is the phase that is seeking to test as many of the ultimate program features as possible. So it's a shorter description because it essentially just says, well, you know, the activities will be set by the other subcommittees, the entry requirements. I apologize. The entry requirements for phase two look similar to phase one. I am going to skip ahead for just a moment to show you that phase three sort of contemplates, I copied and pasted this, but phase three sort of contemplates that the entry requirements will be whatever the ultimate long-term entry requirements should be, whatever is ultimately decided by the working group. But phase two essentially says, scale and test all the licensure program features. It should resemble the ultimate program on a small scale. So again, the actual bullet points here are just sort of to get you thinking. But the answer might be it's whatever the working group settles on in its final vision for their long-term program. That would be phase two, and it would limit it to maybe 3 to 4 areas of law, maybe 4 to 5 counties, with a subsequent phase completely opening the door to all the areas of law that will eventually be eligible in all of the counties in California. That's all I have to say in the way of introducing it, because I don't want to take up too much time.
I just want to say something quick about this proposal so people can respond to it. So what makes this a pilot is that the biggest thing that's happening is in this draft, every 12 months, there's a decision of whether we scale up, right? So it starts with smaller geography, limited subject areas, and then adds to that and expands it with the draft idea of 12 months will be some kind of evaluation piece, which decides whether we then scale up more, right? So we get some information and then make a decision to move into the next expanded phase based on that information. So I don't know if 12 months is the right time frame. I don't know if that model is the right time frame, but the overall feedback seemed to be that a phased approach is what people were leaning towards in a pilot. That if we keep getting positive feedback, or feedback that we feel good that this is protecting consumers, doing what we hope it's doing, that we ultimately get to this more fulsome program. But I'm just pointing out that the draft proposal to react to is that kind of 12-month evaluation process to move into whatever we determine those phases to be. But the basic premise is we start smaller and then build from there based on
where do you get, I mean, is the 12 months just kind of, 12 months seems unrealistically ambitious to me, which is part of the reason that I kind of question doing it this way. I mean, I'm just going to say it. I am concerned that doing it in this manner will actually ultimately greatly delay the ability to have fully fledged paraprofessionals out there operating in the manner that they would be permanently, and with the ability to get feedback from that. And I could be wrong, but I just don't see how, for example, in the first 12 months, you get this up and going, get attorneys who are willing to supervise, get all the documents, like, so for example, we were talking about having a paraprofessional go over a document regarding legal aid opportunities and other things at the get-go. The document would have to be different if the person is working under an attorney's supervision. I just, like, how does this happen in 12 months or 18 for that matter?
Yeah, it's a placeholder, but I think the important thing is we're talking about the timeline, and that's the conversation, one of the conversations we need to have. But I just wanted to flag that because I think the time frame for any pilot, like, is really crucial to what we want to build. And so I just wanted to highlight that that's an important consideration, and this 12 months was relatively arbitrary.
Is 12 months from the date they're licensed and they start taking clients?
It's for us to decide. So maybe that'll be one of the first pieces we get to. So if we could get to I don't know, Chris, did you want to talk about the third potential phase, or if we could please get to the factors? Because we now,
Yes.
okay.
Yeah, and so the third phase, essentially, I won't linger on this slide, but it like I said earlier, it basically just kind of it finishes opening the door. So every aspect of the long-term program is being piloted.
Okay.
And then this is sort of your slide to facilitate the rest of the discussion. It's just, most of these are factors that the subcommittee has expressed to date. We've pulled these from the minutes for the most part.
Thank you. So unless there's any questions on just the tool that we introduced, we have about 40 minutes before it's 11:30 when we're supposed to end. I just emailed Andrea and Christopher. I think our next meeting is already set for 90 minutes, but the meeting we set in the future might be for longer, maybe at least 2 hours, because a lot of these discussions are so important and we really want to hear from everyone. And then I know, Christopher, you said it's perhaps the safety piece isn't as important in this discussion, and I'm glad that you put it in anyway for us to test. But I just also want to caution that in the larger meetings, I think I'm hearing from people that safety is an issue, but it may not be reflected in this particular configuration of the subcommittee. So the other thing I want to say is what I got from the last meeting that we had was that any program should be really flexible, so that even if we're in the first phase, however long it is, if something's not working or something's really working, then we want to be flexible. Like when you're testing a drug, right? If everybody's doing well with the drug, then you knock out the placebo and everyone just gets the drug. So we should remember that we want to be flexible, and also it's important to have a feedback loop. That's what I got from the last meeting. And then the first meeting, we agreed in principle, we support a pilot and that it would be phased somehow. So for the first question, perhaps we should even talk about, do we want different discrete phases? Or to, Justice Petro's point, I mean, do we just want to have, knowing that it's a phase, and the first phase is the experimental phase, and the second phase is we're launching it, we're refining it. So, and then also with that in mind, do we want to talk about how long we think the phases should be, just to start us off before we dig down into the smaller elements?
Yeah, and if I may just add one more framing suggestion. When we talk about phases, the phases could just mean the scope. It could be everything we think that we want in a full proposal, but the only thing that makes it phase 1 versus phase 2 is 2 counties, 2 subject areas, right? But we want to expand that. So I'm just saying that that is an option that is still a pilot. If we want to otherwise structure it in a way that we imagine would be near identical to a full scale program.
So let's start with that piece, because it seems like a threshold piece. Do we want discrete phases? If so, how many? How long do we think the first scope or phase should be? And I guess I should add, do we want the qualifications piece to be fully, like the entry requirements to be fully in place, or are we willing to have like a substitute to get to the ground faster? What do we think? And maybe I should call on someone who hasn't talked for a little while just to balance things out. So Kimberly or Sharon, do you want to weigh in first? Or Julie, do you want to weigh in first?
So this is Kim. I struggle with the entry requirements because I truly do think that if you're going to evaluate a program, whether you think it should continue, you should be evaluating the true program of it. I know with our boards and bureaus, when we start up a program, because again, there's usually no like pilot like this as of late, you know, and unless you're like expanding a scope of practice of an existing licensee, and then you go through the process of, you know, some type of program like that. But for the most part, if we get today a piece of legislation that says we want to allow this new license type, what we would do is we would go through the process of whatever board or bureau is going to get that new license type. They would write regulations, and kind of while that's going along, they would also set up the examination. And usually, depending on how long those regulations and everything take, it would usually be about a year and a half out then that new program, that new license type would start, because you do have to set up your exam, your you know, the education and everything that kind of has to be out there. And a lot of times the education's out there already because it may be coming from another state or something like that. And in this case, I do think we do have a lot of the education already out there. I think the piece where it's missing is that 1,000 or however long attorney supervision. Is that kind of true? Is that right if I'm looking at the licensing requirement?
I'm not sure. I think we get to sort of decide that.
Well, I think it's a great point, Kim, that we haven't really talked about in the licensing subcommittee, meaning Washington certainly has a fully developed educational program for its triple LTs. That educational content had been delivered exclusively by law schools. Because the program has sunsetted, there may be a great opportunity for us to partner with some of those law schools in Washington, or I think there may be only one or two, in an economical way to purchase and adapt that curriculum as opposed to developing it from scratch ourselves. So we haven't quite talked about that, Kim. We've talked about adaptation of paralegal certification training or law school training, but haven't talked about that Washington piece, and that may in fact be a great something to pursue.
One other thing too is some of those individuals, because Washington's program is now defunct, right? I mean, for the most part, we might have individuals, because we're all West Coast, you might have individuals who are licensed in Washington that actually may meet the requirements, you know, whatever those are finalized as, that could come from Washington to here and get licensure early, right? I mean, potentially. So anyway, I say all that to say it does take a while to get into a program, which I think everybody knows that. We just need to decide, you know, what the program looks like and then get it started. But again, I think a pilot, if you're really looking at should it continue, you know, you kind of need to look at the full extent of a program. That was just my point.
Okay, thank you so much. Let's see, somebody else who hasn't spoken for a little while. Sorry, Fariba, go ahead. You had your hand up.
No, I have spoken, so I can wait for somebody else.
Okay, I just want to make sure everyone has equal access to speak, and so that's why I'm doing it this way. Julie, we haven't heard from you, or Sharon. Would you like to say anything at this point, Julie?
I am obsessed and focused on an example of this pilot rollout thing that I recall from about 15 to 20 years ago over at the Department of Insurance. The department and the legislature were very concerned about uninsured drivers. And the fact that at that time, auto insurance was expensive, and people just went naked. They didn't have insurance. They created what was called, in legislation, they created a low-cost auto insurance program and confined it to 2 counties that had the greatest incidence of uninsured drivers. and that was Los Angeles and San Francisco. And it allowed the car insurance to be sold in those counties that was pretty bare bones, but it was cheap, and people were required to get it. And they did. And they did it in such great numbers that eventually this program rolled out to all 58 counties. And it now exists in all 58 counties. I'm just wondering if that's at all comparable, and if we might want to do some research into how it is that the department and the legislature decided it was appropriate to roll it out to all 58 counties eventually.
That's a really good point, to look at other areas and other pilots. Thanks, Julie. And then Sharon, did you want to say anything?
I think that I'm also just contemplating the entry requirements and struggling with that, because we do want it to replicate what an ultimate program will look like, but we also don't want our fate to be like Washington State, where we can't make people won't jump through the hurdles, and we don't get enough paraprofessionals because the bar is set too high. So I'm just wondering how in a pilot we can replicate what we're trying to test for in a proper way, but also get people to sign up for this so that we have enough to test on.
Yeah.
If I could jump in at that point, because I share Sharon's concern, but I think kind of on the flip side, and Sharon, this is Ioana Petru speaking. I'm concerned that if we have something called a pilot with different requirements from what's required down the road, that people aren't going to do it because they don't have any feeling of certainty that they're ultimately going to be able to get a true paraprofessional license.
I'm concerned about that too.
Okay, thank you. And Fariba, thank you so much for your gracious patience. Would you like to say anything?
I love to hear myself talk. I just, my concern is along the same lines, but for a slightly different reason. In that, as I understand it, the licensing committee is allowing for folks who currently are legal document preparers or are legal document assistants or doing essentially the same work, to have the option of continuing without a paraprofessional license or become a paraprofessional. Okay. And my concern is if you present that option saying, okay, you can continue doing what you're doing, charge the same amount and have, the same work basically, or come into this program where you have to go through this onerous, educational requirement, licensing requirement, and be subject to fee caps and have to get a bond, unless, I've said this before, that unless we kind of create this paraprofessional license as the only way you can do this kind of work, just like for lawyers, and if you're doing lawyers work, you're going to be practicing law without a license. I just don't know if we're going to have enough participants, whether it's for a pilot or in the long run.
Okay, and so the question is, do we want to have phases? If so, 2 or none? How long should the phasing process be? And I want to also, because we have such expertise with staff, invite staff to feel free to give us their thoughts. So, I'm just going to say the names in the order I see them: Brady, Linda, Leah, Christopher, Greg, Andrea. Any thoughts that you want to share with us on those questions?
This is Brady. I don't have any comments so far.
Okay, thanks. Linda, anything?
No, I don't have anything to add to what's already been said.
Thanks. Leah, anything? Any thoughts?
No, just a general observation that I do fear this is not going to be viable in terms of getting sufficient numbers of folks interested in serving as paraprofessionals during a pilot phase, and not piloting the program as we intend to implement it. So I don't have a reaction to phasing it, multiple phases, but I think the overall construction may need some redesign.
Yeah. So before, Greg and Christopher and Andrea say anything, let me just weigh in as my, committee member hat. I think we should try to get on the ground sooner rather than later and have some alternative to the entry requirements. So have the entry requirements, work on those, but maybe have some attorney supervision, or have the person be required to be situated in a certain place or certain entity, because I think we should try to hit the ground running, because we have a board of trustees that supports this. Things change, and so if things change, it may never happen. And if we make it too onerous, we just, well, in theory, we'll have this beautiful program, but it won't float. So that's just my thoughts. And then in terms of phasing, I think that we should have two, like, this is our limited scope, this is our limited entry requirements, and then kind of add in pieces, not necessarily in discrete phases, but do a flexible feedback loop and have some evaluation posts, and then say, okay, if things are going well when we're at 8 months, we're going to add in this piece or that piece. And they might be small pieces, but I think we should try to get this on the ground if we can. So that's me with that, committee member hat. And Greg, would you like to weigh in?
Sure. It's an interesting conversation because I think it implicates a much broader question for the entire working group, the state bar, and ultimately the court and the legislature, which is whether or not we are going to create this licensed profession and commit to it, or whether or not we're going to use this pilot program to determine whether or not it should exist. And to the extent, and I think we can't avoid that question because of the issues that we're talking about right now, which is, I don't think a pilot program is going to be worthwhile for us unless we can test those licensing entry requirements and provide a feedback loop based on the data collected to improve those entry requirements, to make sure that the professional that we're bringing into this, into the marketplace is able to provide competent legal services in the way that we want them to. My concern with not testing the entry requirements, you start up immediately with a subgroup of professionals that didn't meet the entry requirements that we're ultimately going to impose. And do they go back, or do they remain as paraprofessionals, or do they have to go back and meet those requirements later once the program goes full scope? I'm not sure how that works. And I also want to echo Justice Patru and Sharon's concern with if there's not a guarantee that this profession is going to exist beyond this phased program, it's going to be very difficult to get people in, at least the type of people that we want to enter this profession, and actually test the program and improve it. So I don't know how you get past that threshold question. I think that was part of the problem with the Washington program, is that they didn't answer that question immediately at the outset. And now they're in this situation where they have to sunset the program. So
yeah, thank you, Greg. Christopher, Andrea, or anybody else who would like to weigh in?
I would just add that, these concerns are certainly very valid from my perspective. I think, these fundamental questions we're talking about are some of the things we framed when we first met as a committee, that tension between fast and what an actual full program would look like, right? I think that's an inherent tension. The issue of, so I think these are the concerns, and whether we talked about, we don't want to have the fate that Washington met, right? And so we talked, at that initial meeting about what would make a program attractive. I think letting people know up front that even if the program sunsets, that they would still remain licensed, as has happened in Washington, but I don't know how much that was signaled in advance. That's one possibility we talked about to make it more attractive. Lower, reduced barriers to entry is something we talked about, although that comes at a price in terms of testing the model. I think these are all of the factors and concerns, and the whole reason that we said we're not sure if we are going to recommend a pilot in the first instance. But my thought would be, and Judge, you let me know what you think, if we could kind of dig into what we think it might look like, and then we can evaluate whether we think it's viable.
I'm happy to, I have some questions that I think will help us frame the next piece of our discussion. But yeah, I agree, Andrea, we could do that too. But maybe just can I check with Christopher and see if he has anything he'd like to add?
The only other thing was there's a precedent for a 3-year pilot with Shriver, but I don't think that involved phases. So I think that if there were multiple phases, 3 years might feel too quick per phase. And the yeah, and just the observation that it sounds like the subcommittee is right, leaning towards trying to capture at least as much of the ultimate long-term features as possible, like without undue delay or expense, or setting the pilot barrier to entry too high, that it ends up undermining the ultimate endeavor. And so there's still the opportunity to throw in 1 or 2 sort of additional, I'm just going to call them safeguards, that could get phased out really quickly, even if they don't end up being in the ultimate program. Like you could have a phase 1 that looks very similar to the ultimate proposal for long-term licensure programming, plus like one, maybe a selective audit of certain work product in the first year or something. So that's just still an option that's in there. But
Okay.
that's it.
I definitely don't want to cut off discussion, but I feel like we're at a crossroads. And so I wanted to define some options for us, and others may think of additional options. So one is perhaps we can go back to the board and ask them how quickly do they want to see a program, because that might be useful for us to know kind of what pace we should be adopting. Second is maybe we're at a crossroads where we want to go back to the whole working group and process this with them and see, do we think that the entry requirements need to be more defined before we start doing a program working on what the pilot should look like? The other is we should just, as Andrea suggests, perhaps we can just soldier on and start building what we think the pilot program should look like, knowing that I don't think we have consensus among this small group. So knowing that we may not all agree with the pace and what comes before the program. So those are some of the options.
So Erica, on the licensing piece of it, while we don't have a final proposal, I think we have a very good sense of where we are. So, I mean, for example, does it wind up being 750 hours versus 1,000 versus 1,200? I don't know. But as far as the general parameters, we know what they are. There could be some changes in response to kind of the state bar's feedback, the board's feedback. For example, there were quite a few general education requirements. There's some discussion happening about maybe if the person took that class quite recently in law school and passed it, that they don't have to do it again, 2 years later. So again, there's some massaging that may happen, but I think we can feel pretty confident that the general feel of the licensing is what it's going to look like moving forward.
Is there a sense then that piece has to be in place so we can't grandfather people in who may have entered in a different way so that we could get the program on the ground faster?
There has not been a discussion that I'm aware of. Again, I'm not a member of that subcommittee and have not, been part of everything, but I have not been aware of Leah can certainly probably the better person to answer that question. Leah, has there been any conversation about grandfathering people in as opposed to requiring them to go through the requirements?
If we want to let people have a different entry bar so that we can start faster.
No, it hasn't come up. So
do we think it's useful to continue to work on what the pilot would look like, knowing that perhaps entry requirements are going to have to be in place before the pilot program starts, which means when pilot program's not going to necessarily start right away?
I'm confused. Leah?
For what?
I think I think there are many like macro questions, and Greg threw out a really good one that I think we do need to grapple with. But one is, will the pilot effort test the licensing requirements, yes or no? So that's a question. Right. And then 2 is, assuming we're still going to have a pilot, how should it be structured? I do think you could bifurcate the licensing issue so that you can still try to move forward with how would we design a pilot, and then come back to, are we going to include in this pilot the fully articulated licensing requirements.
Right.
So I think you could still go ahead and try to develop something. I do see Kim's hand. If you have a few hands up, Jenji.
Yes, sorry.
Just one second though, before you go on to someone else. Leah, the other piece I'm trying to understand, and I've been bugging you for the last few weeks about the whole, does this require legislation? Yes, it does. Would it be possible to start a pilot prior to the legislation, or no? Is this something that like nothing's happening until there's legislation?
Well, I think as I've tried to explain, there's like the political realities versus what technically the state bar, under the authority given to it by the Supreme Court, could go ahead and roll out. And I think that if there were discussions with the relevant legislative committees about what we were doing, and there was agreement and support, I do believe we would be able to kind of get a pilot going, with the understanding that we were working towards a bigger piece of legislation, you know, to take effect at a later date. So I don't think we'd be precluded, but we'd certainly need to have the support and buy-in of those relevant committees, in addition to the express sort of approval of the court.
Okay, so I'm sorry, I didn't see the hands up earlier, and it looks like Sharon's hand went down. But what I want to respond to what Leah said, which is, I think for me, I'm thinking a bifurcated entry requirement so that we can get on the ground. But what I thought I was hearing is that several people are saying they're really interested in testing the entry requirements. And if that's so, then perhaps we're not looking at bifurcation. So Kimberly, did you want to say anything?
I just actually had a question, maybe way back fundamental, because this really, and just correct me if I'm wrong, so maybe this is a question for Leah and Linda, is when this first started and everything, this really was brought out from the Justice Gap study, right? As to why you need a paraprofessional program in California. That's correct, right?
Yes.
Because I mean, for a lot of our other, you know, from my perspective, just with my experience, a lot of why we get new license types or new individuals is because we have usually a group of those individuals that want to be licensed. It's usually them that come forward and bring this forward, usually an association maybe of those individuals, or they're licensed in another state and they want to be in California. So is there a group that's like that here in California, of individuals that believe that they would be close to meeting the criteria, or would have this, you know, want to go down this path to get licensure here? And how big is that group?
That's a good question.
I don't know. I mean, in the licensing subcommittee, right, we're limiting those that would potentially be eligible to those certified paralegals and JDs and LLMs. So that's your entire potential universe.
Right.
And presumably any JD that's passed the bar would not want to do it. So your real universe is folks who have not passed the bar, or who haven't taken the bar, who haven't passed the bar. So it's a fairly small, you know, it's a limited population by design. And then there's the question of how many paralegals would want to do it, right? And so you don't know. So we are trying to get a handle on that universe numerically. We don't know how many will actually want to pursue this career.
Okay, that is something that's a little bit different to some degree from what, you know, like what we're used to dealing with new licensee types. Julie, wouldn't you agree with that based on DCA world? Yeah.
Yes.
Thank you, Kimberly. And Sharon, did you want to say something?
Yeah, just building off of that, would it be possible to do a focus group of folks who are within this population, just to see if they would even apply for this? Because we're operating in a vacuum, and we've been hearing from these other groups, from legal aid, from other groups. And maybe it's even possible to go to Elizabeth Olvera's group, the LDAs, just to see how many of them would want to jump through these hoops. Because ultimately, if we don't get enough people and we don't get buy-in, we're going to be dead in the water with this program.
That's right.
We could ask their professional, like the LDA professional groups, to send out a survey monkey or something maybe. Or the the paralegal groups to send that out.
Mm-hmm.
So we have about 12 minutes left in our meeting today. I think we've had some really good conversations, but I'm not sure we've actually moved forward. And there's an attendee who has his hand raised. I'm not sure if we should go to that. And then I also see Sharon's hand is still up. Sharon, did you want to say something else? Sharon, maybe not. So what are we thinking it would be our next steps?
Judge Yu, and I just wanted to clarify my comment about bifurcation was just a suggestion for how this group could move forward, setting aside the question of whether the licensing requirements are going to be tested, that you could set that aside as a question and still move forward with developing what a pilot would look like separate and apart from the entrance requirements. So I don't know if I was clear, but that's what I was
I understand. And I was taking it as bifurcating the entry requirements.
No, just, yeah.
Which is sort of what I was suggesting, so we could hit the ground running.
Yeah.
Okay. So with what Leah just said in mind, do we want to spend the time? Do we think that's fruitful to set aside the entry requirements and then just work on at our next meeting what a pilot program would look like?
Do we know how close the licensing subcommittee is to finalizing its entry requirements recommendation? I mean, I'm recalling, and somebody's going to have to correct me if I'm wrong, I'm recalling that they're focusing on possession of some sort of certificate, i.e. paralegal or JD or maybe LLM. They might still be looking at those other alternate pathways, one of which is not LDAs to my recollection. They're looking at additional educational requirements on top of that certificate or JD. And they're looking at experiential requirements.
And testing. I think they
testing, you're right. But I'm not recalling the 1,000 hours of attorney supervision.
Oh, it's in there.
It's experiential. So I think they were close until Justice Petru gave the update to the board, and we got that pretty consistent feedback from the board that, you know, that was there was a perception that that was too onerous. And so now we've taken that back to the licensing subcommittee, and I think they're trying to adjust accordingly.
Did the board specify which components were too onerous, i.e. the licensing subcommittee doubled the number of experiential hours along the way?
No, I mean, look, we were very clear, Lee and I both presented to the board, and we were very clear that we were not presenting a final proposal, and therefore there was not like a drill down of we think this number should be 3 versus 6. It was an overall, I mean, certainly there was commentary about the 1,000 hours, but it was an overall impression of the barriers too high if you want to get this going and get people in.
Okay.
I'm just thinking a pilot is going to reveal gaps in the program so that we don't have to start at the very strictest level with regards to entry requirement and everything else. And just like Judge, you said, get something going. And then as the program, the pilot rolls out, then and if we do a really good job on the evaluation piece, then we're going to see gaps that, oh, geez, you know, we only required 500 hours of attorney supervision. We should really require more because here are all this.
But in order to get something going, aren't we really talking about needing attorney supervision? Because it seems to me that the other factor, like, have you worked in the area for a certain number of years? I don't know how on earth we would evaluate that. What does it mean to work in an area? What kind of work? What kind of proof? Can someone just say, I've been doing this for 4 years? That seems just incredibly difficult to me to manage with any kind of internal assurance that we're doing that properly and that the person could actually engage in this kind of representation without attorney supervision.
Well, I'm thinking the group was talking about grandfathering current professionals in, and so it'd be definitely an honor system where they would answer questions on some sort of application. They've been a legal document assistant for I don't know how many years, doing mostly family law, and I'm hearing that family law is one of the areas to be piloted. And so that shows some familiarity with the forms and the process and the procedures. I'm not saying the whole attorney supervision should go away, but just 1,000 hours sounds really incredibly.
Oh, no, I mean, I agree. And I don't know that it should be 1,000 for the final program, but it looked to me like, Greg, were you about to say something?
Yeah, I was just going to say, I don't think we can, I agree with you, Justice Petru. I'm not sure what the 4 years of experience in the substantive area of law would really mean and how we would evaluate that. The 1,000 hours or whatever, how many hours it's going to be of supervised practice is really intended, I believe, to be hours in which the paraprofessional is engaging in the activities that we're licensing them to do, which would comprise the practice of law. So the 4 years of practice in that substantive area, unless they're engaging in the unlawful practice of law, I don't think you can equate it with what the licensing group is envisioning for the 1,000 hours of supervised practice.
If I may just comment quickly on that, again, none of this was a recommendation. It was just brainstorming about, okay, if we're going to do something more quickly and it's not going to mirror exactly the licensing requirements that would otherwise be involved, what can we substitute for that? Just that this is a placeholder, 1,000 hours of experiential, mentored practice or whatever that is. And one of those things was if there were certain individuals, let's say paralegals, who have a lot of substantive experience in a certain practice area, would we be able to pilot with them possibly faster? So it's just one of the things as we're like, okay, what can we do that's faster? And again, there's philosophical questions about whether it sounds like whether we want to pilot anything that doesn't closely mirror what a full program would look like. And certainly that's for the subgroup to determine. But I was just trying to explain where that idea came from.
No, I understand that. I guess what I keep coming up against in my own head is if we think that these people can engage in this practice of law without going through the licensing hoops, then why are we making them go through the licensing hoops? I mean, if we really think that people who've been a paralegal for 5 years can go out and represent people, then what are we doing? Or is that an indication that our licensing numbers or licensing requirements should actually be dramatically decreased?
Okay, so we have 4 minutes left. And first I want to apologize to Jason Solomon, who's had his hand up. I don't think we'll have time, Jason, and I'm really sorry, but I invite you to write your thoughts to, send them to Linda Katz and she'll share them with our committee, and I apologize. It sounds, and then also with respect to grandfathering, I was saying if we have a lower bar for the initial rollout, those people, like Greg had said, what do we do with them? Maybe those people would be grandfathered in. But I think I'm hearing that we should move forward and start to look at what the pieces of a pilot program would look like. I'm wondering if it would be possible to have a member of the requirements committee sit in at our next meeting, because perhaps that might be useful for us to see where they are and what they're thinking, and then they can hear our conversation, because I think some of this is better talked about together without us being a little bit siloed. And I have faith that we're going to be able to put together something. I think we might have to have the entry requirements be somewhat, as Leah maybe, I don't know if she suggested it or is just putting it out there as a possibility, that maybe we need to bifurcate that a little bit along with evaluation and just get to what a pilot program looks like. Because what I think is either we will be able to form a program that we can recommend on February 26th, or we're going to find more holes in our and more challenges to our philosophy and our theories, and we may have to have some additional discussions on some complex issues. So with that in mind, we've got 3 minutes. Any burning questions or thoughts from anyone who would like to say anything?
I would like to get more details on why the Washington program failed. I mean, Greg talked a little bit about it, but kind of help us try to avoid problem areas in the pilot phase, or at least consider it.
There may be notes from prior presentations, or I think there was an article too that was sent around.
Mm-hmm.
There was also a dissent from one of the justices.
Yes.
There was a decision by the court and a dissent from one of the justices. which
I
is,
think we have all of that in the Dropbox. We can make sure that it's all there and resend the link. That's another, I would say you'll get different answers to why it was sunsetted based on who you ask. But certainly we do have a lot of good resource material in the Dropbox.
Good thought. Anybody else with a burning question?
Andrea just mentioned, and I've heard her say this before about 2 meetings ago, possibly confining the initial entrance into the program to people who are already certified paralegals. That's beginning to grow on me, partly because paralegals legally have to work under the supervision of an attorney, right? So that would be easy. That would make it easier to measure whether they have the required number of years of experience is by requiring that supervising attorney to fill out a form verifying that. The Board of Accountancy has a requirement like that because some categories of CPAs who want to do certain things have to have had experience in that particular area. And their employer has to submit a form that they call Form E. So I'm moving toward that a little bit. And maybe we should discuss why that won't work.
Okay.
And I do think it would be helpful to have somebody from the licensing subcommittee at our next meeting who can talk about what they're looking at right now and especially what they're looking to change in light of the Board of Trustees comments.
Isn't Steve Hamilton part of this group? He's just not here today.
Yeah, he's not here.
Yes.
He's part of the licensing subcommittee
Oh,
too.
that's good. Thank you, Greg. So our next meeting is set for February 2nd at 2. Do we want to make that a 2-hour meeting instead of a 90-minute meeting? Kind of give ourselves a little bit more time. Maybe just shoot me an email if that's okay. If your time's already scheduled, we'll just do a 90 and then a doodle will go out.
I'll tell you right now, it's fine for me.
Okay, thanks. Okay, looks like we'll try to make it a 4-hour meeting. If it's okay with Andrea and Christopher, I don't know if they have other things scheduled. So Andrea, you're gonna send out a doodle so we can set another meeting?
Yes, or would people prefer, I know Linda's trying a new strategy as much as we all have a doodle with 85 options. I know Linda was trying a new strategy. Tell us when you're not available. Can I get a straw poll on which method is less annoying?
Doodle for me.
Doodle, okay, happy to doodle, just wanted to check.
And Christopher and Andrea, thank you so much for your hard work. Clearly this conversation was very fruitful and whatever we do, your tool really spawned conversation and that's great. And Jason Solomon, I'm sorry we didn't get to hear from you, but write to us, please. Okay, anything else? All right, have a good rest of the week, everyone, and take care.
Thank you.
Bye.
Everybody.